James Martin, immigration attorney, with the latest developments in immigration law. Today, we bring to you breaking developments on the One Big Beautiful Bill signed into law by the President on July 4th, 2025. This legislation will inject a total of $170 billion into immigration enforcement, with $46.5 billion for a border wall, $45 billion to add 100,000 new immigrant detention beds, and much more money for personnel, judges, and enforcement technology. This expansion effort will make ICE, Immigration and Customs Enforcement, one of the best or the best funded law enforcement agencies in the country. And what does that mean? It means that ICE will be all over the place within a very short time. Within 6 months to 1 year, ICE will be a present force in every major American city, and they will be visible on the streets. The government is taking this so seriously, and they have so much money that they have allocated to this new program that they are offering $50,000 sign-on bonuses to personnel who have law enforcement backgrounds, and they are taking away law enforcement personnel from local sheriff's departments and police departments in order to beef up immigration enforcement. This is causing some problems with local law enforcement because they feel that the federal government is poaching or taking away their employees to the detriment of general public safety. Such measures by the government have sparked fierce opposition by opponents to these actions, and they are trying to reverse these or slow them down by any means possible. However, the Trump juggernaut seems to be unstoppable at this point in time because it has not yet dawned on the American people the actual implications of what is going to be taking place. People do not understand that we will soon see what are effectively concentration camps in this country where many undocumented immigrants will be forced to stay until they are removed from the country. At the same time, the government has limited the number of immigration judges nationwide to 800, which means that it would appear that the government does not really want to follow due process requirements and give people a fair hearing before they are removed from the United States. The idea is to place them in one concentration or a concentration camp where they become desperate and they just agree to leave on their own so that they do not spend months and months in detention. This obviously will be very shocking to the American people because we have not seen the likes of this since World War II when we had Japanese American internment camps. And this will change the political face of the United States. The difference between World War II and the present is that we have social media and people will soon become aware of the impact of these drastic measures. And it remains to be seen whether the American people will put up with it. The next development that we would like to address is birthright citizenship. It has basically been understood and taken for granted that a person born in the United States, subject to the jurisdiction of United States laws, is a U.S. citizen. Of course, people who are not subject to U.S. laws, but who may be born in the United States, are the children of diplomats who enjoy diplomatic immunity. But that is a very small minority of people. On January 20th, 2025, Trump kept one of his promises and sought to reduce Trump kept one of his promises. On January 25th, 2025, Trump tried to keep one of his promises and to eliminate birthright citizenship by way of an executive order. For a person who says he respects the Constitution, he believes that his executive order is more important than the 14th Amendment of the Constitution, which came into being because of the Civil War back in the 1860s. What he tried to do was say that children born to undocumented immigrants are not U.S. citizens. This is an attempt to eliminate what they call chain immigration, where a person can come to the United States, have a child, and have the possibility of becoming a lawful permanent resident through their children when the children turned 21. The government had already knocked out a lot of avenues for people who do these things because people who enter undocumented have a very difficult time becoming permanent residents through their children because they cannot get their papers here in the United States. And there are many provisions that keep them from coming back for a period of 10 years, even if their U.S. citizen children apply for them. There was quickly litigation that went forward on this case. In the springtime, the U.S. Supreme Court, in the decision of CASA, had stated that they are not going to address the issue of citizenship for children because they got hooked up or tripped up on a technicality as to whether there could be nationwide injunctions to stop the enforcement of this Trump executive order. Notwithstanding this, there have now been class actions filed by a number of parties that have sought to enjoin or to stop this new policy by the Trump administration. And so far, these injunctions have held. So for the time being, birthright citizenship is intact. It remains to be seen how the Supreme Court will rule on this issue, but there's strong precedent that a person born in the United States is considered to be a U.S. citizen with the exception noted before. It remains to be seen how this will ultimately work its way through the courts, but it is our hope that the courts will respect the Constitution, which in plain language states that a person born in the United States and subject to its jurisdiction is a U.S. citizen. The contrary would be revolutionary and very harmful to the United States and to many people born here because they would be effectively stripped of their citizenship and subject to possible removal from the United States. In our final development that we would like to discuss, it has to do with immigration bonds for foreign nationals who have entered unlawfully in the United States. What has happened in the past is that unlawful immigrants who are caught and detained by immigration have been able to post a bond and be released pending their immigration court case. That seems to be subject to change due to a recent case decided by the Board of Immigration Appeals. Now the government is taking the position that if a person came to this country unlawfully, they are subject to detention without the possibility of being released. This is being litigated in the immigration courts and will most certainly find its way through the superior courts to decide whether a person who entered the country unlawfully is required to fight their case while they are detained by the Immigration Service and Customs and Border Protection Agency, or whether they will be able to be released out onto the streets again in order to fight their cases in immigration court. Obviously, the Trump administration would prefer to keep people locked up because that way they can force them to get tired and to leave and get more deportations that way by default because people simply do not want to be jailed while fighting their immigration cases. We will see what happens there. On another bond issue, the Trump administration would like to start charging bonds for entry to the United States for certain tourists. So what would happen is people entering the United States lawfully may have to post a bond of up to $15,000, which will be recovered if they leave the United States in a timely manner. So these are the latest developments in immigration law. We will try to keep you posted as this fast-moving practice area changes day by day. If you wish to have further information, please tap on the link below and contact our office. We'll be happy to help you in any way that we can. Thank you.